Good evening, everybody. Thank you very much for coming today. We'll be looking at the U.S. case of Trump against the United States. The bold citation there is the official citation of the case, but the ones that are smaller are the alternative citations you might find elsewhere. The context of this case occurred within the 2020 re-election bid of the 45th President of the United States, Donald Trump. As some people might know, he lost that re-election bid to Joe Biden, and he tried to frustrate the confirmation of President Biden, or President-elect Biden at that time, by mobilizing some supporters to stop Congress from confirming those results. Despite his efforts, Biden was sworn in on the 21st of January as the next president. In August 2023, the Department of Justice decided to sue former President Trump, and there was a grand jury that indicted him on those 4 counts. However, as interesting as the counts are, the president fought back, or rather the former president, I'm sorry, you know he's the current president now. He fought back and appealed interlocutorily to the Supreme Court for an order of certiorari stopping the ongoing prosecution by the Department of Justice. And as you can imagine, since it was not an appeal as of right, it only dealt with some issues and not the main criminal charge. Because of that, the only issue that the Supreme Court dealt with was the scope of presidential immunity from criminal prosecution under the Constitution. There is no legal framework for criminal immunity for a sitting president in the United States. And because of this, the Supreme Court could not look at one holistic source for determining what to decide. And so they had to look at all these sources, Article 1 and 2 of the Constitution, the 12th Amendment, the US Code, which is like the penal law, yes, in the United States. And very famous cases throughout US history, and I'll talk about just a few. The first is United States against Burr. This was in 1809. It was where the Vice President of the United States was tried on treason, but he was impeached first. And the courts relied on this to find out that, a president is not immune from judicial processes, so he can respond to subpoenas, he can provide evidence, the court can give him direction, but that didn't cover criminal or civil liabilities. Then the next very important case is Nixon against Fitzgerald. In this case, someone was dismissed from the Air Force and tried to sue President Nixon because it was due to President Nixon's directive on the reformation of the Air Force that he lost his job. The Supreme Court held in that case that because President Nixon acted in his official capacity, he does not bear any liability for Fitzgerald losing his job. Then there's Clinton and Jones, which upheld that because President Clinton was the subject of a suit related to his private conduct before he became president, he should answer for that. We'll see more as we proceed. Now, what the lawyers for President Trump did was to pick the Fitzgerald decision and expand the coverage of presidential immunity from civil liabilities to criminal liabilities. I say, but after all, he acted in his official capacity. Those were part of his responsibilities. If there was a crime, the Senate should have impeached him, and there must have been conviction before any other prosecution should occur. And if you do this, it will mean that presidents cannot function independently as members of the executive branch. As you can imagine, the Department of Justice opposed this and said there is no statute that gives him any immunity. And there's this beautiful rule of interpretation of statutes. In English, it says what is expressly included is expressly excluded. And therefore, they didn't buy that, and they also said that the conduct was not official, as you can imagine. And there's also the risk of impunity. What the Supreme Court did was to build immunity in 3 subsets. And I'm going to demonstrate this so you can understand. The Supreme Court crafted this as the core responsibilities of the president under the Constitution. If the president acts within the scope, he has absolute immunity. If the president gets down here and does other things which are related to his constitutional powers, he has presumptive immunity. Things like speaking to the public, flying to a foreign country and saying this or saying that. But if the president goes into the audience, crosses this boundary, he has left all of his official duties, and those are unofficial acts for which he can be prosecuted. That statement was enunciated in this paragraph in the majority opinion by Chief Justice Roberts. I'm just going to give you some highlights. The Supreme Court did not use any laws. They just said it is explicit from the principles in our precedent, and it is just necessary. And what was their reason? They said such an immunity is required to safeguard the independence and effective functioning of the executive branch. At a minimum, therefore, a president must be immune from prosecution for official acts unless the government can show that applying a criminal prohibition to that act will pose no dangers of intrusion to the authority of the president. As you can imagine, this was a very controversial decision, and it split the Supreme Court. We had 9 justices, and 3 of them dissented. 1 of them dissented in part, that's to part C, and the rest of the justices agreed, and they made the majority decision. Now, the dissenting justices used very strong language. They called it a mockery of the principle foundational to our constitution and system of government that no man is above the law. And this was very, very tense. As you can see, the language is relying on little more than its own misguided wisdom about the need for bold and unhesitating action by the president. The court gives former President Trump all the immunity he asked for and more. And they restate what the Department of Justice had argued initially, that because the Constitution does not shield the former president from answering for criminal or treasonous acts, they dissented. However, the majority had, of course, read this decision before this time and put their counter or their rebuttal before they had finished. And they said that the dissent's position actually is ignoring separation of powers. And if you were to even follow it to the end, according to Chief Justice Roberts, it will result in a president that does not feel empowered, or an executive branch that keeps on prosecuting itself. This president comes in and seeks to prosecute the former president, and the former president seeks to prosecute and the president before him, and it leads to a very negative spiral. Of course, the political reactions from President Trump were very, very amazing and flowery. I left the capital letters to show you how he put that tweet. It's a big win for our constitution and democracy, as he would put it on Truth Social. And there were other reactions. For instance, President Biden called it a fundamental and dangerous precedent. Then there was House Speaker Mike Johnson and J.D. Vance who supported it, but there was a Senate Majority Leader who said it's a sad day for America. But enough with the politics. To the academia, I chose these very interesting articles because they give some notable viewpoints. Delahunty and Hill were writing in the Harvard Journal of Law and Public Policy, and they believed that the principles enunciated by the Supreme Court were in order so that the Senate could do its work under the Constitution and impeach him if he was found guilty of breaching a criminal offense. And that's why they said it will force other branches of government and ultimately the electorate to take up their responsibility and check the abuse of executive power. They believe that if you don't like a president for whatever he's doing, you either don't elect him or you ask your Congress to impeach him. The next scholar, Mitzga, writing in the Harvard Law Review, believes that it is a deeply flawed decision, and its ramifications will not be known until some years to come. Maybe when we have a president who is more how would I say, more eccentric, for want of a better word. But lastly, we have a very interesting view from Professor Webb, who is a professor of international law at the University of Oxford. She argues that if every country keeps on perpetrating absolute criminal immunity for their presidents, we will get to a stage where we have such a weak system of international criminal law that we cannot enforce accountability. And this is why she says it will be for the international community, including those within the United States who believe in accountability, for those who occupy the most important offices, that is the office of Commander-in-Chief, to unload the gun of unchecked power. So my question for you is, viewing all of these arguments, for and against, what is your view for or against criminal immunity for presidents? Are you in favor of it or are you not?